know Tricia would be very disappointed if I didn't do something like that. So I'll call the meeting to order. Again, welcome and good morning to everybody. Google Meets is a new platform for me, so I appreciate your patience and maybe calling on Tricia, other staff members to help us up from time to time. I did, for those that didn't hear earlier, if you don't have a full tile of everybody, down in the lower right-hand corner, you'll see those 3 buttons, more options, and you'll be able to change layout there and go to tile, and that's what I did just a moment ago, and I have probably 18 or so people up on my tile right now. But we have 25 people on the call, so we will need everyone's patience in getting through this. I'm gonna try to keep my mic open to chair the meeting. I'll ask Tricia to keep her mic open to help me out, and then I would ask everyone else to mute until the appropriate time for us to chime in. We will be doing a vote. I'll ask Tricia, do we need to roll call that vote, or how would you like to do that, by show of hands?
Yes, Mr. Mohair, we will need to do a roll call vote. And in fact, if I can just do an attendance vote real quick. So for each one, I'll just go through everyone's name, alphabetical order. So when I say your name, if it's a vote, obviously just say, aye or nay, whether you are voting in favor of or in opposition to the motion. Right now, if you could just announce it, if you're present once I call your name.
Yeah. Board members, go ahead and unmute now so we don't have a delay.
Thank you. Maureen Baker.
I'm here.
Tom Burrell.
Present.
Jim Foley.
Present.
Amanda Jonas.
Here.
David Mercer.
Here.
Drew Mohair. Lori Overholt.
Here.
Ann Sheehan.
Here.
Scott Sterling.
Here.
And Katie Waddell.
I think Katie is present. I'll ask her to acknowledge.
Katie, can you hear us?
I don't see Katie on the screen anymore.
I don't either.
It doesn't look like Ms. Waddell's on the list of people in the room.
Okay.
It looks like she's joining now. There.
There we go. Katie.
Sorry, I somehow left the meeting.
Okay.
But I'm back.
All right. So we have you marked as being present. For staff present, I have Director Mary Brose Vaughn, Joe Howlett, Tanya Pettis, Josh Laws from the Office of the Attorney General, myself, Tricia Henshaw. For staff assisting with the meeting, is there anyone that I'm missing? All right. So we will go ahead and move on to the next item. Whenever you're ready, Mr. Chair.
So next item is we have announcements. Any announcements that you would like to make at this time, Ms. Henshaw?
Yes. Let's see. All right. Sorry about that. It froze on my end. Just for some general announcements. This meeting is being recorded and it will be made available to the public. It's going to be posted on DPOR's YouTube website. I also have activated our caption, so that is on the screen as well during the recordings. Video of each board member is not required, but we do need to be able to hear you. as we go through the meeting. So if you do lose access, just try to come in as quickly as possible. In the event of you aren't able to get back in, or if members of the public, if they see that broadcast has been interrupted, please notify Tanya Pettis, and her phone number and email address should be on the screen. Tanya.Pettis@dpor.virginia.gov or 804-367-0362. So if for some reason we were to lose the broadcast, we do have to stop the meeting until we are able to get that access back. As I mentioned a few moments ago, all votes will be done roll call vote. So it does make it a bit longer, but we just want to make sure that we have everything documented, especially in light of the electronic nature of the meeting. So when you hear your name, please make sure to unmute your line and state your vote on the matter. For application files and disciplinary files on the agenda, I know there are board members that will need to recuse themselves. When we get to that file, please mute your line as well as turn off your video if you have video access. That's going to make sure that you are recused from the meeting in the same context if you were here in person, but that we can get you back in once that matter is finished being deliberated. So if you run into any issues, let us know before we get into the case, but hopefully that'll work to ensure that we have all the necessary steps taken care of as we go into each of these items. Are there any questions, or for DPOR staff, anything that I left out?
Well, thank you very much. So let's then move on to the approval of our agenda. I'll accept a motion and a second to approve the agenda, please.
So moved.
David
Second.
moved it, and was it Jim Foley that seconded it? Or Amanda Jones seconded? Thank you. So any discussion on the agenda? Seeing and hearing none, ask for a vote, please, on the approval of the agenda.
All right, we're going to do a roll call vote. Maureen Baker,
Approve.
Tom Burrell,
Approve.
Jim Foley. Approved. Amanda Jonas,
Approved.
David Mercer.
Yes, ma'am. Approved.
Thank you. Drew Mulhare,
Aye.
Lori Overholt,
Aye.
Ann Sheehan,
Aye.
Scott Sterling,
Approved.
and Katie Waddell.
Aye.
Thank you. That's all in favor of that vote.
So now move on to the approval of our minutes. If I could have a motion and a second to approve our minutes, please.
Motion.
So moved.
I heard David Mercer make a motion to approve. I didn't hear the second.
Second.
Second by Lori Overholt. Any discussion on the minutes? Hearing none. All those in favor for a roll call vote, please.
All right. Maureen Baker,
Approve.
Tom Burrell,
Aye.
Jim Foley. All right. I can see we're still having an issue with the audio. Okay. Amanda Jonas,
Aye.
David Mercer,
Aye.
Drew Mulhare,
Aye.
Lori Overholt,
Aye.
Ann Sheehan,
Aye.
Scott Sterling,
Aye.
and Katie Waddell.
Aye.
Thank you.
So
All in favor.
now I'll open the, well, before I open the public comment period, Tricia, do you want to discuss how that's going to be handled and who's going to be the timekeeper, et cetera?
Absolutely. As we open the public comment period, this is for any matters that are not on the agenda in terms of application or disciplinary files. I know there are a few of you here for those specific items. As we get to those items, we will ask for any participants to speak at that time. So if you are here to offer comment to the board generally, what would be ideal is if you could type into the chat your name and affiliation if there is one. So if you're with an association, organization that you're representing, that would be most helpful to put that in the chat, mainly so we can make sure to capture it for the minutes and ensure that we put that information into that accurately. Once you are begin speaking for your comment, obviously you'll have it unmuted. Once you are finished with your comment, we will ask you to mute your line. Staff is going to keep track of the 5 minutes to the best of our ability with everything else. So once we get to that, we'll let you know that we're at the 5-minute mark. And so once we finish with the public comment, just as in a board meeting that was in person, we'll ask that you not interject in the proceedings. Any questions on that?
Okay, I'll go ahead and open the public comment period then, please. If you do, as Ms. Henshaw indicated, if you would indicate by chat that you would like to speak, and then you'll be recognized. I think it's I don't see any requests for to speak at this point. I'll give another 30 seconds.
Oops.
Okay, it doesn't appear that anybody is trying to communicate with us to speak during the public comment period, so I'll go ahead and close that public comment period and move on to the next item on our agenda is the review of the files and disciplinary matters. First one is File A 2019-02440.
All right. Thank you, Mr. Chairman. Before we go further on this case, we'll need Ms. Baker to recuse herself. All right. So, Mr. Chairman, the first file is file number 2019-2440. The respondent is Association Community Services West, Inc. And I believe Mr. Dunn, the attorney, is here on behalf of the company. Mr. Dunn, can you hear us?
Yes, I can. And can you hear me and see me?
I believe we can. Yes, sir.
Good.
So,
All right.
Mr. Dunn, I'm going to, before I give you an opportunity to offer any comments on this case, I'm just going to briefly lay out to the board what it is and then kind of go from there. So, Mr. Chairman, this is a consent order involving Association Community Services West, Inc. The charge in the case is a charge for under the board's prohibited act for intentional and unjustified failure to comply with the terms of the management contract, operating agreement, or association governing documents. The respondent in the case has signed a consent order in which they acknowledge an understanding of the charges and neither admit nor deny the violation of the count as outlined in the consent order and report of findings. The respondent is consenting to imposition of monetary penalties and board costs totaling $750. And Mr. Dunn, at this point, if you have any comments that you would like to offer in response to this consent order, you may do so at this time.
I have no additional comments. I just ask the board to accept the consent order. And I know that there's another file after this involving the same entity, but we ask the board to accept the consent order and then we'll take it from there. All right.
Okay. All right. Thank you, sir. Mr. Chair or Mr. Chairman, members of the board, are there any questions? All right. If there are none, Mr. Chairman, we would ask that the board undertake a motion to either accept the consent order as presented It can reject the consent order, or it can refer the case for an informal fact-finding conference.
Thank you. So I'll ask for a motion, please.
Mr. Chair, this is David Mercer. I would move that we accept the request for the consent order.
Do we have a second to accept the motion, to accept the motion to accept the consent order recommendation?
Jim Foley, I so move, or I second.
Thank you. So it's been moved and seconded. Any discussion on the motion to accept the consent order recommendation? Seeing none, Ms. Henshaw?
Yes. Tom Burrell,
Aye.
Jim Foley,
Aye.
Amanda Jonas,
Aye.
David Mercer,
Aye.
Drew Mulhare,
Aye.
Lori Overholt,
Aye.
Ann Sheehan,
Aye.
Scott Sterling,
Aye.
and Katie Waddell.
Aye.
Mr. Chairman, the motion passes unanimously.
Thank you. We move on to the second case, please.
Yes, sir, Mr. Chairman. The second case is file number 2020-1152. The respondent is Association Community Services West, Inc. It is a consent order. The consent order has a single count under the charge of the board's prohibited act for failing to act in providing management services in a manner that safeguards the interest of the public. As with the previous case, Association Community Services West is acknowledging an understanding of the charges and is neither admitting nor denying the violation of the count outlined in the report of findings. The company is agreeing to monetary penalties and board costs totaling $1,650. Mr. Dunn, is there anything that you wanted to say regarding this case?
No, I don't have anything additional to add. Again, ask the board to accept the consent order. Thank you.
Thank you, sir. Mr. Chairman, as with the previous case, the board can accept the consent order as presented. It can reject it, or it can request an informal fact-finding conference.
Good. So open to a motion, please.
Move to accept the recommendation.
I second it.
So Mr. Mercer made the motion to accept the consent order recommendation. Ms. Waddell seconded. Any discussion?
Yes, Mr. Chairman. Joe, could you give another sentence or two about the violation itself?
So the facts supporting the case, and let me just say it begins on page 21 of your agenda, and the report of findings begins on page 24, and that outlines the basic facts at issue in the case. And this had to do with the election of the officers of the association and the company's responsibilities in that process. So the information, the facts are outlined in the report of findings. If board members want to take an additional minute or two to take a look at that, but that's basically what the issue in the case is.
Mr. Sterling, do you have any specific questions on the case?
No, I have to tell you that I'm a little bit of a disadvantage. I thought I would be able to read through this material at the same time we have the screen up, and I haven't been able to figure out how to do that. And I didn't print what seemed to be several hundred pages of this material. So I was just curious as to what the violation might have been.
Sure, understood.
Mr. Chairman?
I'm not sure who's speaking. Oh, Tom Burrell.
This is Tom Burrell. What is the company doing to ensure that this doesn't happen again?
Mr. Dunn, would you like to address that?
First of all, as far as not happening again, the allegation deals with the violation dealing with tabulating votes. The allegation in the findings of fact is that the management person that was appearing at the particular meeting left before tabulating the votes. And there is some dispute as to the actual findings of fact, but ACS has decided to go forward and resolve this to close this chapter and continue on that. As far as what will be done in the future, ACS will continue to man the voting, will participate, and will continue to make sure that those procedures are followed. I can go into more details about some of the facts, but
Mr. Chairman, this is Mary Brosnan. As this is a consent order, if the board requires additional information, it really should refer to an IFF rather than additional discussion.
Thank you for that clarification. So the motion is on the table to accept the recommendation to approve the consent order, and it's been seconded. And so we'll now move to a vote. If the vote is denied, then we could discuss further action.
Thank you, Mr. Chairman. Tom Burrell,
Aye.
Jim Foley,
Aye.
Amanda Jonas,
Aye.
David Mercer,
Aye.
Drew Mulhare,
Aye.
Lori Overholt,
Aye.
Ann Sheehan,
Aye.
Scott Sterling,
Aye.
and Katie Waddell.
Aye.
Mr. Chairman, the motion passed unanimously.
Okay, before we discuss the next case, I would like to just mention to the board that this for me anyway, some 750 some odd pages. There's several aspects to it. So my question is, will we be dealing with each violation has its own recommendation? Will we be dealing with those separately, or we be dealing with those in summary?
That's the pleasure of the board. If you want to take up each of the violations that are listed, and Mr. Howitt will kind of lead you through the specific violations that are in the summary and recommendation. And so there will be discussion of the violations first, and then once a decision is made on that, then if appropriate, we'll proceed to the sanctions. I do know with this particular matter, there are several board members that will need to recuse themselves. So I would ask at this time if you all could mute and turn off your video, and just to make sure those that I have listed are Maureen Baker, Amanda Jonas, David Mercer, and Ann Sheehan. Does that reflect the recusals for this matter?
It does.
Okay.
All right.
Excellent. Thank you.
All right. Mr. Chairman, the next case begins on page 29 of your agenda. File number is 2019-655. The respondent is DCRE Management LLC. And as I understand it, I believe Mr. Catlett is here on behalf of the company to address the board at the appropriate time. Mr. Catlett, are you available?
I am available. Thank you.
Okay. And then I also believe Ms. Storms, who was one of the complaining witnesses at the IFF conference, is also indicated she was planning to participate today. Ms. Storms, are you on the call?
Yes, I am. Thank you.
Okay. Is there anyone else here on behalf or in reference to the DCR Management LLC case who was a participant at the IFF conference? All right. Seeing none, Mr. Chairman, this case comes to us as a result of an informal fact-finding conference that was presided over by Ms. Jonas on behalf of the board. As indicated earlier, there are several violations charged in the case. They're all charged under a single count of the board's regulation for the intentional and unjustified failure to comply with the terms of the management contract, agreement, or association governing documents. And so the first violation under the count deals with the annual inspections at the community that filed the complaint with the board, and whether or not the management company adhered to those requirements in the contract. The second violation deals with the various management fees that were charged by the company, by the management company to the association, and whether or not that was done in accordance with the requirements of the contract. The third violation relates to modifications and changes to the contract. The fourth violation deals with the holding of monies in an escrow account. And the fifth violation deals with the books and records of the association. And the report of findings, Mr. Chairman, if you want details on the specific facts that were used to bring the case, the report of findings begins on page 44. The recommendation begins on page 29 of your agenda. The presiding officer of the IFF conference is recommending a finding of violation, or a finding of a violation on count 1 with respect to violation number 2, and is recommending that with respect to violations 1, 3, 4, and 5, that the board close those aspects of the count with a finding of no violation. And so at this point, Mr. Chairman, we do have Mr. Catlett, who is here. He would be entitled to have 5 minutes to respond to the recommendation presented to the board. And Mr. Catlett, before I have you begin, I'd ask that you keep your remarks to the summary and recommendation presented by the presiding officer of the informal fact-finding conference. The board can't go beyond the record of the case that's in front of them. And so, Mr. Catlett, if you're ready, you may address the board.
Yes, thank you so much. First, I want to thank everyone for their time today. I understand this is the opportunity to speak with the DPOR board prior to their vote to accept, reject, or amend the summary from the IFF conference. It's been confirmed in the summary that my firm, DCRE Management, had complied with the management agreement with regard to those violations concerning inspections and reporting, contract renewal increases, routine and non-routine invoices, contract modifications, escrow accounts, and the transition of documents upon termination. I'm asking the DPOR board to accept the presiding board member's recommendation in the summary of no violation on violations 1, 3, 4, and 5. Violation 2 in this summary has been amended to reference a letter dated May 10th, 2018, from the Lakes at Red Rock Board to DCRE Management, indicating, effective immediately, DCRE's authority to expend or commit association funds, obligate the association, or communication on behalf of the board and the association is terminated. In accordance with Article 11, Paragraph F of the management agreement, which clearly states no variations, modifications, or changes of the agreement shall be binding unless it is made in writing and executed by both parties. The Lakes at Red Rock Board's unilateral action is in violation of the agreement and without legal justification. And this was pointed out to the Lakes at Red Rock Board by my attorney. This was not included in the complaint, and yet another example of the misrepresentation of the facts by the attorneys on the Lakes at Red Rock Board that prepared the complaint based on the investigators' interview notes. Based on this and the following, I would request the DPOR board to reject the presiding board member's recommendation on violation 2 and amend this to no violation. Following contract termination, I was anxious to fulfill my responsibilities and conclude our business. I cooperated fully with the new management company by signing checks in their possession for the operating account. And I submit my final invoice along with a schedule of amounts due in accordance with the terms of the agreement. When my invoice was not processed timely, my attorney and I made several attempts over the following months to learn the reason why, even suggesting a meeting with the Lakes of Red Rock Board to review the details. In late August, my attorney finally received a response from the Lakes of Red Rock Association's attorney on my outstanding invoice, falsely claiming I would not meet with the board and my invoice was not in accordance with the agreement. This is included in the complaint and yet another misrepresentation of the facts. The Lakes of Red Rock Board then proceeded to file the false and misleading complaint with DPOR, issued a notice to my community that a complaint had been filed, and went even further by distributing the actual complaint to my community in which I live. This made its way onto the next door community site, and the entire area was now aware of the complaint. Not only is this completely inappropriate behavior towards a homeowner, but clearly a violation of the Code of Virginia for knowingly filing a false complaint and also for disclosing information of an ongoing investigation. I imagine as licensed attorneys in the state of Virginia, the board members were well aware of this, but that didn't seem to concern them. My attorney attempted to resolve the outstanding invoice issue and continually instructed the Lakes of Red Rock Board to cease the defamatory statements around my company. With no resolution, he suggested I close the operating account and secure those funds earmarked for my invoice in a separate account.
Mr. Catlett, I just want to let you know you have 1 minute remaining. Sorry to interrupt.
Thank you. The escrow account was something I set up for the sole purpose of working with the Lakes of Red Rock Board on a resolution, and the funds sat in this account for over 2 years without a single response from the Lakes of Red Rock Board. My attorney concluded after 2 years that neither the Lakes of Red Rock Board or their attorney were coming to the table, and we had sufficiently made every attempt to try to work with them and could close out my invoice for services and legal charges with payments from those funds in the escrow account. While you may not fully agree with the advice I chose to accept from my attorney, I would ask you to put yourself in my shoes. In dealing with a board that maliciously set out to defame my reputation in the community in which I live with statements and notices, by filing a false and misleading complaint to DPOR, and by refusing to work towards resolution on my final invoice in accordance with the terms of my agreement. Given the facts around this, I don't see how DPOR can state unequivocally that this rises to a level of intentional and unjustified failure to comply with the management agreement. And I'm asking the DPOR board to dismiss the entire complaint by finding no violation for each of the 5 violations from the IFF conference. The public damage caused to my reputation.
If you could wrap up your comments because we're just over the 5 minutes. Thank you.
I will. Thank you. The public damage caused to my reputation and business cannot be undone. And as a licensed common interest community manager and certified principal, I feel DPOR has an obligation to look into this unethical behavior and the violations by the Lakes of Red Rock Board in accordance with Title 54.12351 of the Code of Virginia, General Powers and Duties of the Board concerning associations. There was no justification for the Lakes of Red Rock Board's actions, and they need to be held accountable. Thank you so much.
All right, Mr. Chairman, I believe Ms. Storms indicated she was here. Ms. Storms, are you still on the call?
Yes, I am. Good morning.
Okay, Ms. Storms, you'll have 5 minutes to address the recommendation of the presiding officer from the informal conference. Again, as I had asked Mr. Catlett, please keep your remarks to summary and recommendation presented by the presiding officer and the case that was discussed at the IFF conference. and you may begin.
Thank you. Good morning, CIC board members. Thank you for the opportunity to address the board. I was on the Lakes at Red Rock Board of Directors beginning 2013 through September 2020. I am still active with the Lakes at Red Rock on HOA matters, and I volunteer my time as a member of the Covenants Committee. I believe my comments are relative and relevant to the CIC board's review of this serious matter. Page 4 of the IFF points to the HOA's bank records, which show in 2016, the monthly management fee of $3,550 was paid to DCRE, and in 2017, the monthly amount was $3,600, and January through May 2018, the monthly amount stayed at $3,600. The IFF at page 5 states that the 2018 proposed budget DCRE submitted to the board, quote, reflects an increase in the management fee, end quote. I believe the reference to Exhibit R-8A is in error, and it should be Exhibit R-8B. I do not know what this exhibit is, however, but I assert that there was no budget increase proposed by DCRE in the 2018 budget. Further, if you examine the proposed budget for 2017 and the notice of the approved 2017 budget, you will see the budget proposes $3,550 per month, but the 2017 bank statements show monthly payments to DCRE of $3,600 per month. The IFF finding cites to the HOA board's approval of the annual budget as the basis for the increase in the management fee, which the IFF found such increase did not require a contract amendment. By the IFF's own reasoning, the $3,600 DCRE paid itself in 2017 was not approved by the board during the budgeting process. If you align the approved budget with the subsequent bank account withdrawals, you will see DCRE withdrew more than the budgeted amount. The IFF provides that Catlett always provided invoices for routine and non-routine services in accordance with the agreement. I do not agree with this finding. As provided on page 5 of the IFF, the management agreement states that the agent shall submit invoices, quote, no more than 30 days after the completion of the non-routine service. On June 29, 2018, DCRE submitted the May 31, 2018 invoice for $3,120 to the HOA's new management company. This invoice includes activity going back as far as 2012. The invoice has 2018 as the date DCRE completed the items, which entry conveniently concludes with, quote, completing contractor warranty inspections and closed out project file. I submit that this invoice is manufactured and that DCRE manufactured this invoice in order to seem compliant with the contractual requirements to submit invoices for non-routine services no more than 30 days after the completion. DCRE never brought up that he would be invoicing or charging the association for these so-called non-routine services. He knew as early as March 2013 that his contract would not be renewed. The monthly management reports provided by DCRE to the association show that activity referenced in the invoices were all completed and concluded sometime in 2017, some 6 to 15 months prior to DCRE submitting the invoice. I submit that this was an intentional violation of the management agreement. Concerning the IFF finding of violation 2 on page 11, the payment of the $3,120 amount to DCRE after the HOA informed him that the invoice was not approved and he had no authority to disperse funds, I agree with the IFF finding that this was an intentional and unjustifiable violation of the terms of the agreement. DCRE had a dispute with his client and he decided to take the money without any authority. The fine should be much larger to prevent and deter this type of activity.
You have 1 minute.
Yes.
Thank you.
Concerning the IRR finding on page 12, I believe the word medication is a typo and should read amendment. Nevertheless, the IRR asserts that standard industry practice for managers to submit fee increases through annual budget proposals is sufficient for modifying material contract provisions. This reasoning is simply misplaced. Normal contract rules interpretation require amendments to agreements and not vague industry standards. This is the purpose of Article 11F, which requires all notices to be in writing. The same Article 11I provides the process for the parties to provide notice, and industry practice is not listed. I would like to request 15 more seconds. Regarding turning over of the books and records to the new management agent, DCRE was aware as early as March 2018 that the HOA was going with a new management company.
And violation number 2, again, deals with the fees that were charged by the management company. And on page 39 of your agenda, which corresponds to page number 10, or excuse me, page number 11 of the informal fact-finding conference summary, the presiding officer recommends the board find a violation of that, find a violation with respect to that violation under count 1, and this pertains to the disbursement of funds first to an escrow account and ultimately to the company and Mr. Cadlett after the association board had terminated its authorization to disperse funds and deny approval for payment of funds. The presiding officer concluded that that was an intentional and unjustifiable violation of the terms of the management agreement, and that is the basis for the finding of the violation there.
So the motion that I recommend is to accept the recommendation to hold violation 2 and impose a monetary penalty.
Mr. Chairman, we wouldn't be able to, I apologize, we wouldn't be able to address any monetary penalties or for any violations until after the board votes on the finding of a violation, finding of violations based on the recommendations in the summary. So it's a 2-stage process. The board would have to accept the finding of a violation, and then once we've gone through all the violations, we would go back, and then for those violations where the board determined there was a violation, then the board could address any sort of sanctions.
Thank you, and my apologies to Ms. Henshaw because I think she told me that yesterday. So thank you very much for that clarification. So the motion would be to approve the recommendation to hold violation number 2.
This is Jim Foley. I move to follow the. Oh my goodness! I so move.
Do we have a second?
I second it.
Any discussion on the motion? If I may, I concur with the recommendation that this was not followed through on civil remedies, and so I concur with the recommendation. All those in favor, please roll call vote.
Yes. So the motion is to accept the finding of a violation for violation 2 in the summary and recommendation. So Tom Burrell.
Aye.
Jim Foley.
Aye.
Drew Mulhare.
Aye.
Lori Overholt.
Aye.
Scott Sterling.
Aye.
And Katie Waddell.
Aye.
The motion passes unanimously.
So now we have violation 3, which is also in dispute. Joe?
All right, Mr. Chairman, beginning on page 40 of your agenda, which corresponds to page 13 of the, page 12 of the informal fact-finding conference summary. The presiding officer is recommending the board find no violation on that aspect of count 1. And again, that has to do with the modifications to the management contract.
So I'll like to accept a motion to regarding violation 3 to accept the recommendation of the presiding officer.
So moved.
Tom Burrell has made that motion to accept the recommendation is to close violation 3 with no further action. Do I have a second?
Scott Sterling, second.
It's been seconded by Mr. Sterling. Ms. Henshaw. Oh, I'm sorry. Any discussion on the motion? Seeing none, hearing none. Ms. Henshaw.
Yes. So Tom Burrell.
Aye.
Jim Foley,
Aye.
Drew Mohair,
Aye.
Lori Overholt,
Aye.
Scott Sterling,
Aye.
Katie Waddell.
Aye.
Mr. Chairman, the motion passes with a majority, unanimous vote.
Thank you. Now we move to page 41 on your packet. We deal with the recommendations for violation 4. Go.
Yes, that's correct, Mr. Chairman. So yes, beginning on page 41 of your electronic agenda and page 13 of the informal fact-finding conference summary, the presiding officer recommends the board close violation 4 of count 1 with the finding of no violation. And that violation, Mr. Chairman, relates to the establishment of the escrow account following termination of the contract.
So I'll ask for a motion to accept the presiding officer's recommendation to close violation 4 without any further action.
Jim Foley, I so move.
Been moved by Mr. Foley. Do I have a second?
Second.
It's been seconded by Mr. Burrell. Burrell, any additional comments? Hearing none. Ms. Henshaw?
All right, so the motion is to accept the recommendation as to violation 4 and make a finding of no violation. Tom Burrell,
Aye.
Jim Foley,
Aye.
Drew Mohair,
Aye.
Lori Overholt,
Aye.
Scott Sterling,
Aye.
and Katie Waddell.
Aye.
Thank you, Mr. Chairman. The motion passes unanimously.
Okay, thank you very much. If I have this correct, I believe we're now on page 43 of the packet regarding the recommendation on violation 5.
That's correct, Mr. Chairman. Page 43 of the electronic agenda, which corresponds to page 15 of the informal fact-finding conference summary. And the presiding officer regarding the violation 5 outlined in count 1, the presiding officer is recommending a finding of no violation. And that has to do, again, with turning over the books and records of the association.
Thank you. So I'll accept the motion to accept the recommendation of the presiding officer to close out violation 5 without any further action.
So moved.
It's been moved by Mr. Burrell.
Second.
Been seconded by Ms. Overholt. Any discussion? All those in favor? Ms. Henshaw?
Yes.
Sorry.
No, you're fine. So for the motion to accept the recommendation for violation 5 and find a finding of no violation, Tom Burrell,
Aye.
Jim Foley,
Aye.
Drew Mohair,
Aye.
Lori Overholt,
Aye.
Scott Sterling,
Aye.
and Katie Waddell.
Aye.
All right, thank you. And Mr. Chairman, that motion passes unanimously.
So,
All right, now, Mr. Chairman, the board has found a violation only with respect to violation number 2, outlined in the IFF conference summary. And so the recommendation of the presiding officer with respect to that violation is recommending that the board impose a monetary penalty of $1,000. And so the board can either accept that recommended sanction or it can choose to change it.
So do I have a motion to accept the recommendation of the presiding officer for a charge of $1,000?
I make the motion to accept the recommendation.
Second.
And Mr. Burrell has seconded. Any discussion on the motion to accept?
Yeah, this is Scott Sterling. Are we allowed to inquire of Joe or Tricia or Mary? Is this sort of consistent or within the bounds of what the board has imposed in the past for similar violations?
So, Mr. Chairman, I have an answer to that question. The board's appears to only have one previous case involving this prohibited act, And in that case, the board imposed a monetary penalty that was $3,750. I don't have the case file immediately in front of me. So the board does have has precedent dealing with this particular prohibited act, but it's really only one case. So it really isn't enough to make a determination to say the board has an established upper limit or lower limit.
Thank you, Joe.
Any other questions, comments, proposed amendments? Hearing none, Ms. Henshaw.
All right, so for the motion to accept the recommendation as to the sanction, Tom Burrell,
Aye.
Jim Foley,
Aye.
Drew Mulhare,
Aye.
Lori Overholt,
Aye.
Scott Sterling,
Aye.
and Katie Waddell.
Aye.
All right, thank you all, and that motion also passed unanimously.
Okay, Mr. Chairman, that concludes that case. The next case we have on the agenda is the license application case, and all of the board members who are currently recused can come back into the room. And Mr. Mulhare, you are the presiding officer in this case, so we'll need you to recuse yourself.
Thank you. Let me just figure out.
Okay. So we have Ms. Baker, Mr. Mercer, Ms. Sheehan, and alrighty.
And just real quickly, Mr. Mercer, as vice chair, we'll need you to serve as chair on this particular matter.
All righty.
Thank you.
All right, bear with me 1 second. Let me catch up to the board here. So the next case on your agenda begins on page 753 of your agenda, and that's an application case for Deborah K. Bagley. I think we heard Ms. Bagley is here, and I also understand that Ms. Bagley's attorney may be participating as well. Ms. Bagley, are you here? Sorry, Ms. Bagley, can you hear us? Okay, how about Ms. Cope? Bear with me. 1 second. I'm checking to see if they're on the call. It looks like Ms. Bagley may be still on the call. There's an area code of a number with an area code beginning 540. Is that Ms. Bagley? How about Ms. Koch? All right, Mr. Chairman, it's not clear if those individuals can hear us or not. We may want to give another couple more seconds to see if they might be able to check in. Otherwise, if you are agreeable, we can go ahead and move to considering the summary in the case.
And since Ms. Bagley did indicate at the beginning of the meeting that she was here to speak, I would maybe recommend if you want to have Mr. Howitt kind of introduce the matter, and we'll then go back and see if maybe Ms. Bagley or her attorney was able to go out and come back in to hopefully be able to speak.
Okay.
I think under the circumstances, those are reasonable recommendations. Let's go forward with the summary.
All right, Mr. Chairman. So again, beginning on page 753 of your agenda is a license application case for Deborah K. Bagley. Ms. Bagley has applied for a principal of supervisory employee certificate. On her application, she disclosed potentially disqualifying disciplinary action taken by the real estate board. Ms. Bagley originally had an informal fact-finding conference back in the spring of last year, and the case came before the board at its September 2020 meeting. At that time, the attorney for Ms. Bagley requested that the case be returned or remanded for an informal fact-finding conference to receive additional information. The board approved that request, and so the informal fact-finding conference was reconvened. Mr. Mulhare presiding over the informal fact-finding conference. The presiding officer is recommending that the board approve Ms. Bagley's application for a principal of supervisory employee certificate. And that recommendation, Mr. Chairman, begins on page 757 of your electronic agenda. And is Ms. Bagley or her counsel present?
I did see someone go out with a 703 area code, so they may be trying to get back in.
Can you hear me now?
Perfect, yes.
It was automatically muting me for some reason, so I don't, anyway, I finally pressed *6 and now I'm unmuted. Sorry about that.
All right. So is it Ms. Koch or Ms. Coach?
It's Koch. It's Denise
Koch. Okay, Ms. Koch. I apologize.
No,
is your client also available?
I know she's on the line, and
okay.
she might, if Miss Beagley is on the line, she can press *6 to unmute herself as well.
Okay.
Yeah.
And Ms. Koch.
Okay. Can you hear me now? This is Debbie Beagley.
It sounds like we can. So, Ms. Koch,
okay.
You would have 5 minutes to address the recommendation before the board, and as we advised the previous individuals who have had cases, just could keep your remarks to the informal fact-finding conference summary and recommendation in the case that was discussed at the IFF conference.
Yes, sir. Thank you. I do, on behalf of Ms. Beagley, I want to thank the board for allowing this case to be remanded for that reconvened IFF. And I want to thank Mr. Mulhare for his consideration of the additional evidence that was presented at that reconvened IFF and his, of course, recommendation that Ms. Beagley's application for certification as a principal or supervisory employee be approved. I wanted it to be reconvened, the IFF to be reconvened, because I did think it was important for the board to understand that Ms. Beagley was not intentionally disregarding the rules and regulations. She was just understandably confused. As you know from reviewing the summary, Ms. Beagley had actually submitted 2 applications around the same time, one for her certification and one for NRV Property Management's application for a community manager's license. On the community manager's license application, she put the business address in Radford for NRV Property Management. And then for her application for her own certification, she put her home address in Blacksburg. When she received the license actually has her name on it and her Blacksburg home address. So because of that, she mistakenly thought that that included her certification as a supervisory employee. So she understood the rules and regulations and requirements for certification. She just mistakenly thought that she actually had been certified. So that's where the confusion came in. As soon as she realized after the original IFF, reading the summary, she realized for the first time that she actually hadn't been certified. And at that time, she immediately stopped providing management services because, again, she was aware of the rules and regulations. So yes, she certainly made an honest mistake during this application process, but she has clearly learned from those mistakes, and she has taken this process as well as her duties and responsibilities as a community manager very seriously. I do appreciate Mr. Mulhare's and the board's concern for the safety and welfare of the public, of course. But I think it's clear, particularly from those letters that we presented during the IFF from her clients, that Ms. Beagley does provide a valuable service to the associations that she serves, and that granting her application for certification would be in the best interest of the public. Therefore, I would respectfully request that the board accept the summary and grant her application for principal or supervisory employee certification. And if it's okay, I know this has probably only been a couple minutes. If it's okay, I would like Ms. Beagley to just say a few words to the board.
That's fine.
Okay. Okay. Thank you. This is Debbie Beagley, and I want to thank the board and Mr. Mulhare for consideration of my request for certification as a supervisory employee. I've learned a lot from my mistakes that I made during this process, and I can assure the board that if it grants my request, I will continue to work extremely hard to stay apprised of the rules and regulations that govern my profession and to serve the communities in my area with the utmost honesty, integrity, and professionalism. Again, I'd like to thank the board, and I hope that I am given the opportunity to continue doing the job that I love, which is providing the valuable management services for my clients. And it's the services that they come to expect and that they deserve. And once again, I thank the board for your time.
Okay. All right. All right, Mr. Chairman. We've heard from Ms. Beagley and council. So again, the recommendation presented to the board is for approval of the certificate. The board can accept that recommendation, or it may reject it.
The chair would like to entertain a motion to accept the recommendation.
So moved, Scott Sterling.
I second.
Thank you. Trish, can you call for the vote?
Certainly, Mr. Chairman. Maureen Baker. Aye. Tom Burrell.
Aye.
Jim Foley.
Aye.
Amanda Jonas.
Aye.
David Mercer.
Aye.
Lori Overholt.
Aye.
Ann Sheehan.
Aye.
Scott Sterling.
Aye.
Katie Waddell.
Aye.
Thank you, Mr. Chairman. The motion passes unanimously.
Excellent.
All right. Mr. Chairman, that is all of the cases we have on the agenda. So Mr. Mulhare is welcome to come back in the room if he would like.
Well, we'll have to think about letting him back in, I guess.
And thank you all. I am going to leave this meeting now. I appreciate it. Thanks so much.
Thanks for your
Once again,
participation.
thank you
Bye-bye.
again, and I too will be leaving. I appreciate everything you've done.
All right.
Thank you.
All right. Thank you.
All right.
Drew, where are you, man?
Trying to come back in.
All right. So, Mr. Chairman, as I was advising, that's the end of the cases. I believe the next items on the agenda are for regulatory matters. And so beginning on page 990 of your agenda is just an update on recent regulatory actions by the board. The first item is the amendments to the timeshare regulations. The board adopted those amendments at its September meeting, and those amendments were to conform the regulations to the changes in the Timeshare Act that had occurred during the 2020 General Assembly session. Those amendments were filed with the registrar on September the 9th and published in the Register on September the 28th, and they became effective on December the 1st, 2020. And in addition, as a side note, Mr. Chairman, earlier today, we posted a notification to the timeshare developers regarding those amendments to the regulation, as well as updates to some of our timeshare forums related to that change. The other item on the regulatory actions update are the pending amendments to the Common Interest Community Management Information Fund regulations. There's no new information related to provide. Those are still pending an executive branch review. Once that review is completed, it would be submitted to the registrar for publication in the Virginia Register, and then a final public comment period would begin before the regulations finally become effective. Do any members have any questions on the regulatory actions update? All right. So, Mr. Chairman, the next item on the agenda begins at page 991, and that is what is included there is a proposed revised guidance document of the board. Originally, this guidance document, which deals with the distribution of timeshare public offering statements and the format, it was originally to include the format of the timeshare public offering statements. Back at its September meeting, Mr. Chairman, the board authorized staff to go through the process of revising all of the board's guidance documents to update them to reflect the recodification of Title 55. However, during review of this particular document, it was determined that more substantive changes were needed in order to reflect other changes that occurred in the Timeshare Act that made portions of that previous guidance no longer operative, specifically regarding the format of the public offering statement, because the statute used to specify compact disc, and that caused some developers to be confused about whether or not they could provide it in other formats that were other electronic formats like a flash drive or file sharing platform. And so after reviewing the Timeshare Act changes and the guidance document, we thought it was appropriate to bring this before the board again for their review and consideration to adopt the revisions to reflect those changes. If the board elects to adopt the revisions, these would need to be posted for a public comment period before the guidance document could be become effective. Do any members have any questions? All right. So, Mr. Chairman, if the board's agreeable, if the board wants to take a vote on whether or not it wants to adopt the revisions outlined adopt the revised guidance document.
Before I ask for that motion, just some clarification on my end. Basically, the developer is going to need to provide the public offering statement prior to the execution of the contract.
That's correct, Mr. Chairman. So the provision in the Timeshare Act, it already currently requires that the prior to the execution of the contract, that the purchaser be provided a copy of the public offering statement. What this guidance document specifically addresses is the developer's obligation that that prior to the execution of the contract, that not only that they deliver the statement, but that they provide the purchaser with an ample opportunity for questions and answers. And so what the guidance document previously required was that the developer either include in the first page of the public offering statement a disclosure about that, about its obligation, or that it include the disclosure of that obligation in the optional receipt of documents page that they can provide to a purchaser when they give them the public offering statement. So basically, what this guidance document still does is require the developer to disclose to the purchaser when they get the public offering statement that they have to give them an opportunity to review it and ask questions.
Right. That ample opportunity to ask questions is what in the middle of that sales process is what was interesting to me. But neither here nor there. I take a motion to accept the recommendation.
So moved.
Been moved by Mercer, seconded by
Ms. Jonas.
Thank you, Ms. Jonas. Any discussion on the motion? All right, hearing none. Ms. Henshaw.
Thank you, Mr. Chairman. Maureen Baker.
Aye.
Tom Burrell.
Aye.
Jim Foley.
Aye.
Amanda Jonas.
Aye.
David Mercer.
Aye.
Drew Mulhare.
Aye.
Lori Overholt.
Aye.
Ann Sheehan.
Aye.
Scott Sterling. Scott Sterling.
My mistake. Aye.
Thank you. Katie Waddell.
Aye.
Mr. Chairman, the motion passes unanimously.
Thank you.
All right. All right, Mr. Chairman, lastly, for me, I have page 995 of your agenda is a document we've prepared regarding the Common Interest Community Manager regulations. And there's two items we'd like the board to consider today. Just as an overview, the Common Interest Community Manager regulations, we would like to undertake a regulatory review process of the management regulations, the manager regulations. So the document that you have in front of you outlines some of the issues we'd like to look at during the regulatory review process. We'll want to ask the board to consider establishing a regulatory review panel to take a look at the regulations and address and propose any specific changes to the regulation. And then the other would be to authorize staff to initiate the regulatory review process with a filing of a notice of intended regulatory action. So those are the two items that we'd like the board to consider regarding this.
And if I may, Mr. Mulhare, for the committee, just as kind of background, some of you have been around through the various regulatory reviews. This board has customarily done general reviews, or certainly with the establishment of new regulations, has utilized committees of stakeholders. Typically, it'll consist of a few board members and then a few members of the public in kind of looking at how we've handled the CIC manager regulations and kind of the scope of how those regulations impact the various stakeholders. Our recommendation would be to have several managers, of course, on the committee. We would also suggest, based on our past practices with committees, to have an attorney that is involved in CIC management or CIC issues. We also would, of course, look to have an association representative on the committee. And then finally, because of the interesting interplay that the real estate board has with the CIC manager regulations, specifically if there is an action, a disciplinary action that potentially involves a real estate licensee who is also a CIC manager, then the real estate board has the authority to take action in that matter. We have had a real estate board member also sit on the committee when we do that. I will also let you know that we did have one familiar name that is a former board member, but then was also on the first, at least one, maybe two regulatory review committees, Paul Orlando, who is supposed to be enjoying his retirement. He reached out and has expressed interest in participating in this committee. And we have a few other thoughts, but of course, wanting to see what board members may be interested. And then ultimately, we would ask that the board authorize staff to work in conjunction with the chair to finalize the list of committee members kind of within those parameters that we've talked about, if the board agrees with those.
So Mr. Orlando would be volunteering as a member of the public?
Yes. And of course, his background is as a CIC manager.
Right, right. But we still want managers and we still want board members. So how many board members are you asking for?
There's not a particular number. We tentatively put about 3. Obviously, we'll need someone, a board member, to chair the committee. The board chair, of course, always serves as an ex officio member of any committees. Certainly, we have a couple of managers at our that are on our board. So certainly, if there was interest by Mr. Foley, Mr. Mulhare to serve on the committee, but of course, anyone else, not limiting it to that.
you suggesting that I could be an officio and an ex officio?
You can certainly be a member of the committee. Certainly your expertise as a CIC manager. However, if you choose or for whatever reason are not on the committee, you're still on the committee because you are as an ex officio member, so you can always attend the meetings and participate.
I'll join the, rather not chair, if that's okay.
Who was that? Was that Jim Foley?
Yeah.
Perfect.
I was going to offer the same. I'm happy to be on the committee, but I'd rather not chair.
I said it first.
You were just faster to the button.
Is there another board member that would like to join this effort?
And while they're contemplating that, I do have to correct my previous statement. The chair does not necessarily have to be a member of the board. That's not to say that everyone can be off the hook. Someone has to chair the meeting.
Well, I do have a great recommendation for that. So when we get to that point.
Fantastic. So we have, we could start off with approval to establish the panel, and we have, and then those that have volunteered. That's really going to be the focus of staff bringing that together initially, and then electing a chair to move that forward. Is that right? Okay. So can I have a motion then to establish the panel to undertake this review of community association manager licensing?
So moved.
Jim.
Been moved by Jim. Do I have a second?
Second.
Thank you. All right. So it's been moved and seconded. Any discussion? And now I guess as we move forward, we just ask anybody that would like to volunteer on this particular task to make their names known to staff. But so Ms. Henshaw?
Yeah, and if I may, real quickly, while we're under discussion, there are, just as a point of reference for the previous ones and looking through some of the managers and participants and that type of thing, one of our former board members was actively involved in the initial regulatory reviews, and that was Chris Melson. He did move, so he wasn't eligible to serve on the board anymore, but if the board so chose, he could certainly be invited as a committee member as in the manager spot. He is still actively practicing in Virginia. He just, his residence moved across the state line. And then there was in the past, and this is not to put anyone on the spot, even though it's going to appear to be, we did have the CPA member of the board participate on the committee, just because that was some valuable perspective given their work with associations. Again, not to put anyone on the spot. We could certainly, explore that more, but just want to give you that background.
I've been sitting here thinking I'm interested. I don't want to chair, but I would be interested just because of some of the aspects of what's required for the managers to disclose. I would be interested in being on the group.
Okay.
Oh, let's just put it out there. We all think Paul should chair.
So I think we have a motion and it's been seconded.
All right. So for the roll call vote, if we're ready for that, Maureen Baker.
Aye.
Tom Burrell.
Aye.
Jim Foley.
Aye.
Amanda Jonas.
Aye.
David Mercer.
Aye.
Drew Mulhare.
Aye.
Lori Overholt.
Aye.
Ann Sheehan.
Aye.
Scott Sterling,
Aye.
and Katie Waddell.
Aye.
Thank you. That motion did pass unanimously. And so we will work with the chair and the members of the committee on getting that first meeting set. It'll be in the next few months that we'll kind of get that together, but wanted to get the opportunity to have the official go ahead for that.
That's great. And I do anticipate being an active participant in that. And it sounds like we can put this committee together fairly rapidly. We just need some representation from the legal side.
There's a, Mr. Chair, I don't know if you all are, there's a woman that practices in my firm, Trigiani. I don't know if she might be interested.
I'm going to have to get some more background on, no.
Yeah, I agree. Please do not mention that I raised her name.
There won't be a video out there to support it at all.
All right.
Yeah, and I think the sooner the better putting this committee together while we're in the video mode, because it's very convenient.
Mr. Chairman, the other item is for the board to consider our authorizing staff to file the notice of intended regulatory action if the board is so inclined.
I'll accept that motion, please.
So moved.
Second.
Second.
Did Tanya catch that? I missed that.
Second.
I think I got it. Yes.
Thank you. Perfect. All right. So it's been moved and seconded. Any discussion?
Mr. Chair, just to, so that you all will know, purposefully, we will wait to actually file the NORA until we have the committee together. So that would be deliberative, but we would like the authorization to do so now.
Thank you. I think we're ready for a vote.
All right. So Maureen Baker.
Aye.
Tom Burrell.
Aye.
Jim Foley.
Aye.
Amanda Jonas.
Aye.
David Mercer.
Aye.
Drew Mohair.
Aye.
Lori Overholt.
Aye.
Ann Sheehan.
Aye.
Scott Sterling.
Aye.
And Katie Waddell.
Aye.
All right. Thank you. That motion also passed unanimously.
Okay. All right, Mr. Chairman, it looks like that includes all the regulatory items that I needed to cover. Thank you for your patience.
Thank you. I believe we're ready to move on to other business. Is our favorite ombudsman with us?
Unfortunately, Ms. Gillespie could not be with us today. She's had an eventful couple of months, so she can't join us today, but she did get us her annual report, or not her annual report, I apologize, her most recent statistics. So those were provided via email yesterday and then are also hopefully on the screen for you to see what she's been working on. I will let you know one of the kind of notable changes that she wanted to make sure that I shared with the board on her behalf is the different way that the agency is handling timeshare complaints. In the code, timeshares have always been set apart from common interest communities. Fortunately for us, when Heather came on board, everything was new, and so she reviewed those incoming complaints as well, just to be able to provide some consistency in all the new things that was under the authority of the CIC board. Over the years, it has come to make sense to shift the timeshare complaints that are not really, again, a common interest community to our normal complaint process that we utilize through the department, where those complaints would go through our complaint analysis and resolution section when they're received. And so they do an initial intake. If necessary, we reach out to a board member, those types of things. But again, it would just put it on the trajectory that we utilize for all the other CIC manager complaints and those types of things that don't deal with those internal issue with associations and the internal complaint process. Are there any questions on that? I will try my best.
So in the list of complaints then that she has in this report, that doesn't include any timeshare.
It's going to include some because this is a very recent change just within the last 2 to 3 weeks. But the next report would reflect the change without the timeshares being included in that.
So will we get any report on that separately?
There, right now there is not, but I can certainly work to see what I can compile for the board to at least have some data related to the timeshare complaints, if that would be helpful.
Thank you. Any other questions or comments?
Mr. Chair, this is Scott Sterling. It surprises me a little bit that with everybody sitting at home or working from home or being home and having things not to do outside the house, that there aren't a spike in calls and emails rather than a drastic reduction. Leaving that aside, I have a hard stop at 11 o'clock. I want to thank you and Tricia and the staff, Joe, yeoman's work today. It's good to see you all. And although my picture still isn't up there, but I presume you can see me.
I can.
And maybe next time we will get a chance to bump elbows.
Thank you.
Amen. Be well, and I'll see you next time. Thanks for everything.
Thank you so much, Mr. Sterling.
Any other questions, comments regarding the Ombudsman's report? Ms. Henshaw, do you anticipate any kind of additional guidance going out to the associations, the management companies, kind of targeting in on these issues, annual meetings and elections? Basically, we have a cloud of COVID over many of these complaints, and I'm just wondering. I know there was a real flurry of activity regarding annual meetings and the state's guidance on board meetings versus annual meetings, things like that. I was just wondering if any additional guidance is anticipated along these lines.
As of right now, the board is not involved insofar as being directed to prepare any specific materials. With that being said, Heather is the front line on all of these questions and things that come up. Obviously, with our current circumstance, our education and outreach is somewhat limited unless we're asked to participate in a virtual meeting or something like that. We don't have all the opportunities we did before to kind of get out there and provide that information. With that being said, though, I will say I'm not on every email list by any means, but I know I see from the common interest community attorneys throughout the Commonwealth information going out to associations and information that they're posting, which is what we as an agency would normally direct folks to is certainly to those in the industry that are doing this every day and looking at it from that perspective. That would probably be the best route to go with something like this, where it is kind of dependent on what an individual association has in their governing documents and their processes and all of that's not really something that this board typically gets into, those internal workings, if that makes sense.
Let me ask the question a little bit differently. Those principally are attorneys, but those that are providing the continuing education to managers for their licenses, they submit essentially agenda, so to speak, to get approved to provide the education and what they're providing. Is wondering if we could try to be proactive on reviewing those applications and making sure that they're covering these kind of COVID issues.
So the courses that are required for our certified employees and cover any updates to laws and regulations, they do not typically submit those for a review purpose. They may submit them to supplement their registration file when they add that information, just because the board determined some years ago that those kind of changes that are necessary to adapt to the changes in the law don't have to be re-reviewed after the initial review. It's just if there were to be a substantial change. I would certainly anticipate that, all of the laws and regulations classes that cover those updates each year are going to, by necessity, include those changes, which I will go over in a minute, to the legislation related to electronic meetings.
Thank you.
And I did see Ms. Waddell had her hand up, so I don't want to miss that.
Yeah, the only thing I was going to say is I agree with Drew, because of these reports that we get from Heather. If you noticed, a lot of the complaints are still the same. They're still related to the meetings and the elections and lack of communication and so forth. There doesn't seem to be a change. We're still getting the same kind of complaints as we were last year. There may be less of them, but we're still getting the same kind.
Okay. Well, I don't want to delay the process. Any other comments or questions? All right, so let's move on. We have the legislative update.
And I will say, for this board, this is probably the shortest legislative update that I've ever had to give. Obviously, there were other priorities and things like that our legislature was dealing with this year, but it was remarkably, on our part anyway, in terms of what we monitor and what we are involved in. It was a less than active year than what we were used to. But I did want to just highlight a couple of pieces of legislation real quickly, just to put them on your radar in case they are not. One actually deals with what we were just talking about, House Bill 1816. And I was going to try to share it, but I don't want to mess up our connection. House Bill 1816 actually deals directly with electronic meetings for associations and their boards and that type of thing. And so it does allow electronic meetings of those association boards, committees, those types of things. Obviously, there are certain things that the provisions in the law get into about guidelines and things like that have to be established under the particular association. But it does certainly take into account the current environment that we all find ourselves, and made some modifications to that legislation. And it involved a collaborative effort by CAI along with the Virginia Realtors. DPOR staff was invited to review some drafts along the way so that we could also provide input. And so again, that's HB 1816 that was presented this session. Now, ultimately, it has been continued to the special session, and that's kind of where I have the last thing, making sure that's correct. Because
Hey, Tricia.
Yes.
I think the House bill has passed both houses and is signed by the governor.
Okay, that's why I was like, wait a minute, this is not the end of the story.
Yeah.
Okay, so that has gone through. Thank you. I apologize for not having my complete listing here. The other one I wanted to mention is HB 1842. This is a bill that addresses smoking rulemaking authority for associations. This this topic was introduced last year by Delegate Keem, and it was at that time put into the Clean Air Act part of the code, if I'm not mistaken. And obviously, when our folks in the CIC world saw that and saw it affecting these multi-unit buildings and that type of thing, all of the alarms went off for our CIC community. And so there was action last year that put it for study with the Virginia Housing Commission. And so it went through the CIC work group of the Virginia Housing Commission, and the ultimate result was pretty much the legislation that's in HB 1842. And essentially it defers to, as many of these provisions do, the declaration and the governing documents for the associations, but it gets into allowing rules and in some cases prohibitions against smoking. So all of that is again going through HB 1842. So if you want to take a look at that. And the final piece of legislation, I'm going to stop on that because I see a couple of hands up.
So did I. I think Maureen was one of them. I didn't see who else.
Yeah, this is Maureen. I know this isn't going to happen for 3 years, but with the passage of the marijuana for recreational use, is that bill from smoking going to extend to marijuana as a
Yes.
secondhand smoke,
Yes.
like nicotine is?
Yes.
That was specifically discussed in committee and during the debate, yes. And as well as, the method of transmission, whether it's a, vape device or have you, the more traditional.
So you're saying, yes, that should be expanded in the next few years?
The bill passed already covers.
Oh, okay.
Yes.
Okay, thank you.
All right.
And the last one I just wanted to mention, it's not CIC specific, it more so is one that to some degree impacts DPOR. House Bill 2321 creates a new Secretary of Labor. As you may recall, last year we had kind of given a brief update that the DPOR, who had previously been directly under the Secretary of Commerce and Trade, was put under the Chief Workforce Development Advisor. So this legislation takes the Chief Workforce Development Advisor and creates the Secretary of Labor cabinet position. And so DPOR, along with, I believe, VEC, the Virginia Employment Commission, and Department of Labor and Industry would also fall under that Secretary of Labor. To be kind of more in line with, those workforce issues and things that, we all kind of are involved in. Is there anything that, I know Mary was so much more involved in all of this than I have this year.
It was a very strange session. I just wanted to highlight one other bill. Well, there were several fair housing bills, but one of interest, just because the case it stems from involved a common interest community, a condominium, clarifies that in the fair housing law, a request for accessible parking is to be treated as a reasonable accommodation, not a reasonable modification. There had been some concern as a result of a Supreme Court decision, and then HUD was not liking that Supreme Court decision, in that the way our law was written, some accessible parking requests were treated as reasonable modifications, which means that the person with a disability would be paying for that. And so House Bill 1971 clarifies that accessible parking requests are reasonable accommodations. And again, still subject to all the fair housing requirements, that it not otherwise be overly burdensome and administratively burdensome and the like.
Great. Any questions? Maurice, your hand is still up. Do you have another question?
Sorry, I'll press the lower hand button. Sorry.
Anyone else? All right. Well, thank you. Let's move on to the next item on our agenda is the program review committee membership. From my experience on this board, this is a great committee to be on. It's fabulously run by Maureen, and we have a vacancy.
Yes, and Mr. Chair, this kind of gives me an opportunity, although not one that I would necessarily want to take, but we're going to ask the board to consider filling the vacancy that was created when our previous board member, Eugenia Reese, went off the board, who is an association representative, but not to, shift gears, but I am shifting gears. I would suggest that maybe we wait unless there is someone who is very excited to be on the committee, since that has been an association member seat. Mr. Burrell, sadly, will be going off the board. Sadly for us, is going off the board after this meeting within the next month or so. Good for him though, because he's making a move across our southern border, so he will no longer be eligible, unfortunately, to serve on the board. But we would ask for that reason to kind of delay filling that until we get our full board membership up.
Sounds reasonable to me. I don't see anybody raising both hands to jump in. So can we just move forward then? Great. D4 updates as it relates to COVID-19 response.
Yeah, Mr. Chairman, these are just a few quick things that pretty much are repeats of what we have shared at previous meetings. As you all were advised previously, when the governor issued the executive order for the emergency, surprisingly, a year ago this month, the language included provisions that would allow agency heads to issue waivers of regulations, so not statutes, just regulations, if they found that it was helpful in mitigating the spread of COVID-19 and ensuring that we, did our part to limit gatherings and all of those things. And so we have several waivers that are in place. They continue to be in place as of right now. One of them that affects our regulants is the extension of expiration dates up to 30 days after the end of the emergency. And last I checked, there's not an end date on the emergency, so that continues. There also is, of course, the waiver of any regulations that prohibit or limit online or distance learning. And then there is another one that came in, I believe, since the board last met, but it doesn't affect the board. But just to let you know, there is a waiver of any regulations that require the physical presence of a licensee at a place of business. And so that gets to some of our programs have specific regulations that require a licensee to be physically present. When we're talking about remote working and all of those different things, the requiring someone to be physically present in an office or in a place of business doesn't really work. We are continuing our operations in the agency. The building continues to be closed to the public. We do have some meetings that are happening in person. We do have some boards and committees and that type of thing that we are able to accommodate in person. But many of us are doing virtual meetings for right now, just to do what we can to, ensure those safe practices. We continue with teleworking for staff. Our call center hours are still at a reduced schedule of 8:30 to 1 o'clock, which means that, our email exchanges are up. We have not heard any negative feedback or any concerns about not being responsive or not getting the information that's needed through that. And again, it's just another effort on our part to not only protect our regulants and the public coming into the building, but also our employees who are having to keep everything going despite some of these challenging circumstances. So that's kind of where we are with our current COVID-19 response.
I'll just lead off by making a comment. My hat's off to the director and your staff, Mary, and just been, it's a worn out term now, pivoting, but from my experience, D4 has done a tremendous job in responding and making the function of the Commonwealth still happen. And I've reached out to Ms. Henshaw. I've reached out to investigators in our routine, and Joe and others, and everyone is really just doing an extraordinary effort to maintain the business of the Commonwealth. So my hat's off to you, Mary.
Thank you very much. The team here is just exceptional, and they've really come through.
Thank you. Moving on, we have our financial statements.
Yes, Mr. Chairman and members of the board, as always, we put the financial statements on the agenda for your reference. And of course, these take into account some changes last year, I believe it was, where any of the excess funds were moved into a reserve fund for certain purposes to be used by the department. And so the statements you have are reflective of that. In addition, we include the recovery fund financial statements, again, for your information, so that you know where we stand on our recovery fund.
Great. So we all had a chance to review that. Are there any questions regarding the financial statements? And you have to remind me, do we need to move to accept the financial statements, or we just move on?
They're just informational purposes.
Thank you. Thank you. I don't see any questions. Move on to our event calendar.
Yes, Mr. Chair, members of the board, while we aren't doing nearly as much education and outreach as we used to do in past years, we do have a few things that we have been doing. Heather will be doing a presentation for Reese Broom as soon as they can get that scheduled. And then back in December, both Heather and I are members of the CIC work group, and we were asked to do updates for the CIC work group, which is chaired by Delegate Bulova, to update on what all the CIC board has been working on, and also what the Office of the Ombudsman has been working on. And so we had an opportunity to share that information. And I have to give a shout out. The chair of the work group, Delegate Bulova, was extremely complimentary of the newsletter that Joe worked so hard to put together, and shared how he distributes it to the associations that are in his jurisdiction. And so that was great to hear. That I knew it was a great information, but to have that kudos there was pretty neat.
Awesome. I agree. Any questions, comments? Moving on to the election of officers.
Yeah, we actually normally do these in December. Obviously, with our meetings postponed last year, we have carried on just fine, but we do need to go ahead and do our annual elections. And so this would be starting after this meeting. And so this is the one motion that I have to handle every year. And it after 12 years of doing it, I still get anxious about doing it correctly. Unlike Mr. Mulhare, who has it all down. So to start with, I would accept nominations for chair of the board.
I would move that we renominate Drew Mulhare.
A second.
All right. Are there any other nominations.
I'd love to compete if somebody else would love to nominate.
I do not see those raised hands, Mr. Mayor.
Well,
With that,
I'll accept that nomination.
wonderful. Well, with that, so we will have a motion to close nominations. We have we have a motion by Mr. Mercer to have Mr. Mulhare continue as chair, second by Ms. Overholt. And so with this roll call vote by acclamation, with his acceptance, Mr. Mulhare will continue as chair. So I'll go to the roll call vote. Maureen Baker.
Absolutely.
Tom Burrell.
Aye.
Jim Foley.
Aye.
Amanda Jonas.
Aye.
David Mercer.
Aye.
Drew Mulhare.
Aye.
Lori Overholt.
Aye.
Ann Sheehan.
Aye.
Mr. Sterling has left the meeting. And Katie Waddell.
Definitely.
Thank you. That was passed unanimously. Congratulations. I think, Mr. Mulhare, I am delighted to continue working with you, and I will turn it over to you for nominations of vice chair.
Well, first I'll make a comment that Ms. Henshaw and staff facilitates this to make it as easy as possible, and I thank you for all your efforts in that regard. Also, would like to thank the other board members for your support and contributions last year and as we go into this year. So I'd like to accept a nomination for vice chair, please.
I'd like to make the nomination for David Mercer to be vice chair.
Is there a second?
I'll second.
Okay, it's been moved and seconded for David Mercer as vice chair. Any other nominations for vice chair? Okay, seeing none, roll call vote, please.
All right, Maureen Baker.
Aye.
Tom Burrell.
Aye.
Jim Foley.
Aye.
Amanda Jonas.
Aye.
And here's the test. David Mercer.
Aye.
Drew Mulhare.
Aye.
Lori Overholt.
Aye.
Ann Sheehan.
Aye.
Scott is absent. Katie Waddell.
Aye.
And that motion passes unanimously. Congratulations, Mr. Mercer, on continuing to serve as vice chair of the board.
Thank you. Glad to help.
Thank you.
Are we now ready for other board business?
And as for me, Mr. Mulhare, surprisingly, I have no other board business. So certainly if you all have any other items.
I have a question that if we're at the point, this disclosure form that was sent to us, the one we normally sign, the conflict of interest, was the necessity for me and others to recuse themselves from several items today. Is that something that gets noted on this, or is this just a financial disclosure?
The one that was sent to you, I don't have one in front of me, but you will list that for any item that you recuse yourself from today. And then that goes with the minutes, just to note that you did recuse from that item on the agenda.
All righty.
And I'm trying to remember where I saw that, and I don't recall.
It just came in just before the meeting from Tanya.
Perfect. Okay.
Yeah, it's the normal conflict of interest form that you
Right.
would fill out.
Sure. Okay. Any other comments or questions? Well, again, I want to, we'll take a motion to adjourn here in a moment, but again, I just want to extend my appreciation to you all for your participation today. It was a long meeting, especially getting through that one particular case. I appreciate your patience and endurance through all of that. Again, I want to thank our director, thank our staff for the extraordinary work that you're doing for all of us in the Commonwealth. So with that, I'll accept a motion to adjourn.
So moved.
Moved by Mr. Mercer. Any second?
Second.
Second by Ms. Jones. All those in favor, please raise your hand. Thank you. Have a great, unless you needed a roll call for that.
Nope, that one, we do not need one. I just want to say thank you all so much, and thank you as always, Mr. Mulhare.
Thank you. Have a great day.
Thank you. Have a good one, guys.
Good to see you.
Bye, everybody.
Bye-bye.